Talk. Professor Hamilton here, aka the Legal Plug. Welcome to Legal Studies 101, and today we're going to talk about successions. Why is this important? Well, first of all, having a will keeps down a lot of the foolishness that happens after someone in your family dies. The reason why I wanted to do this course is to let you guys know that you don't have to have a whole lot of formalities to generate a will. A succession is the legal process of settling a deceased person's estate and transferring the property and rights to their heirs or legatees. In Louisiana, there are two types of successions. There's a testate succession, which means that the person died with a will, and intestate, which means that they did not have a will and that property will devolve through the laws of the state of Louisiana. So what is a will? A will and testament is a legal document that determines how property and rights will be distributed after a person dies. In Louisiana, there are two types of wills, with the first being an holographic will, which is entirely written in the person's handwriting, dated and signed by the testator, which is the individual that's writing the will. And then there's a notarial will, which is prepared in writing, signed by the testator, and notarized in the presence of two witnesses. You can simply write a will in your own handwriting and date it and sign it. So what's so important about having a will? Well, first of all, it allows you to name your heirs and specify what property they receive. It also lets you choose the executor of your estate. And most importantly, wills help to avoid disputes amongst family members. So who are the heirs and the legatees? What does that mean, right? Heirs are individuals that inherit property under Louisiana intestacy laws when there is no will. Legatees are individuals that are designated in a valid will. So let's talk about forced heirship for a second. Forced heirship is when there are people that are under the age of 24 or disabled that received a forced portion of the estate, which means that regardless of if there's a will or no will, they are going to receive 25% of the estate if it's one, and 50% if there are two or more. The reason why that's important is because if there's a child under 24 years old that can inherit by law, or they're disabled, they are going to receive the forced portion, period, point blank. So let's talk about a few key terms. Usufruct. Usufruct is the use of a piece of property by an individual, and naked ownership is the ownership of it, but not the use. Sometimes that's important because in a will, you can designate the use of a property and the naked ownership. Another key term is the executor or the administrator. When you have a will, you can designate who you want that person to be. So that could be somebody that you trust to handle your estate after your death. So let's briefly talk about how to start a succession. Well, you can file a petition in court and you can start a succession that way. You need to do an inventory of all the property, and let's dive into that for a second. So when we're talking about property, we're talking about property and rights, okay? And so sometimes that can become confusing because we're like, well, they didn't own their house. Yeah, but how many times have you seen people fight over a Bible or a plant or china, dishes? Those are the types of things that you can list in your will if you want to handwrite one, or in the item description if you're going to file a succession in court. Once that inventory descriptive list is done, then the court will appoint an administrator of the estate. Thereafter, you're going to need to pay all the debts, and then the property is then distributed to the heirs or legatees according to their portion. If you die without a will, Louisiana law will direct how your estate is transferred to your heirs. So depending on your relationship to the person, there is a hierarchy of relationship status in which the property and rights are distributed. So if you don't want Louisiana law determining how your assets, your property, your rights are distributed amongst your loved ones, then it's a pretty good idea to have a will. And as I said before, it's as simple as writing everything down, dating it, and signing it. So let's go over a few common questions about successions. Does a succession require court? No, it does not. If you have an immovable property that is worth less than $125,000, then it doesn't require a full succession. Another common question is, can I disinherit someone from receiving my property? Yes, you can disinherit someone for multiple reasons. Those reasons are abuse, neglect, and criminal acts. So what happens if there is no will? The property will be distributed in accordance with Louisiana law. So how long does succession take? Well, it can take a few months or it can take a few years. It just depends on how much property is involved. So here are the top reasons why you should plan your estate: to avoid family disputes, to protect loved ones and especially forced heirs and children, and also to minimize tax and legal costs. Thank you guys for joining me today to talk about successions, and I will see you in class on Thursday at 7 p.m. Central Standard Time.